Let's talk about a common workplace scenario. So employee A writes an email to HR of an employer B and is making a complaint of race discrimination, for example. It is very tempting for employee A to want to email the email that they just wrote making the claim to themselves. So they want to send a work email to their personal email. That can sometimes cause problems. Let's talk about it. First and foremost, if you have a company email, that is the property of the company. And the data that is created when you make an email or the copy of that email is company property. In many respects, you aren't allowed to send it to your own personal Gmail account to keep it for your records because it's not yours. It's stealing. So when can you do it? If you feel like you must, because say like eventually you're fired and you no longer have access to it. One of the reasons that you really can't do it is because there are certain laws that speak about the fiduciary obligations of an employee. In other words, an employee has an obligation to not steal or to protect the property of the company. And revealing that information can put that employee in a lot of legal jeopardy, especially where employees work for companies that handle a lot of confidential information. Maybe it's a hospital or a financial institution, like a bank. You have a lot of confidential information, financial, medical. Companies are very, very careful about that communication that an employee has with fellow coworkers. And they are very protective of that information. They want it to stay in the hands of the employer. It could be one of those things where if you start regularly sending work emails or work product to your personal email or keeping it on your personal computer, and the company can see that because you're using their server, you run the risk of getting into some trouble. The company has a right to be concerned about that. But there are also laws that say that a person may preserve information that they may use for the purposes of potential and future litigation. So if that's true, now all of a sudden, it does sound like an employee has a right to forward emails to their personal email. If that person does presume that maybe the information will be used for potential future litigation, they really are allowed to have it. And for a company to turn around and accuse them of some sort of impropriety or illegality would be a stretch. But at the same time, what constitutes for the purpose of future litigation, right? If it's just an email about the day's events and not much more, well, then that probably doesn't qualify. However, that email that you send that describes some sort of illegality that you see or discrimination or some other issue, well, that does probably qualify. You just have to be very careful in terms of what you decide to forward. And that kind of leads to another topic. The idea of recording your employer is not also advised. It certainly isn't here in Illinois. We're what's called a two-party consent state, which means that you can't record someone without their knowledge in a place that they would not reasonably expect to be recorded. An employer or a supervisor or a manager who is working on the clock for the employer or on the employer's premises does not reasonably expect to be recorded by their employee. And so it's not really a good idea to record someone at work if you're an employee without their knowledge. This doesn't go both ways. On the flip side, an employee should have some reasonable expectation that they are being recorded. You are essentially a guest at an employer's place of business, and that employer has the right to monitor that place of business at their own discretion. Think of all the places that you might work where there are security cameras, a bank, hospital, you name it. Anyone who works there has a reasonable expectation that they're being recorded, but it just doesn't go the other way. The employee should not expect the employer to understand that they're recording them without their knowledge. So it's not recommended. However, there are some ways around it. And one of those ways is just writing yourself a note. If there's a conversation that you think you might need to remember for purposes of litigation, end the conversation, sit down, send yourself an email or text of the who, what, when, where, and why of that conversation. I was in this room at the office. It was this time of the day. This is the person who was in the conversation with me. This is what they said. This is what I said, et cetera, et cetera. And then just keep that document. It's still hearsay. Doesn't mean that you get to use it in a court of law, but you can use it to refresh your recollection. That's what we tend to suggest in terms of trying to record things or keeping information that is your employer's. Kind of a no-no, but there are caveats. So always good to call, talk it through, see what sort of information might be helpful to know before you make the decision to do that.